Good afternoon. I'm Lonnie Brown. I'm the Associate Dean for Academic Affairs here at the Law School, and it's my honor and privilege to welcome you to our 110th Sibley Lecture. This preeminent lecture series honors the memory of John A. Sibley, a 1911 graduate of the law school. During his long life, Mr. Sibley distinguished himself as a lawyer, banker, and unparalleled supporter of the university. After attaining great prominence as an attorney with the highly respected Atlanta law firm of King & Spalding, he became general counsel to the Coca-Cola Company and later chairman of the board and president of Trust Company of Georgia, now known as SunTrust. Throughout his enviable career, Mr. Sibley was always a devoted and influential alumnus of the university, serving as president of the UGA Alumni Association and playing a major role in the capital campaign that led to the construction of this building. In addition, he was integral to the law school's effort to obtain full accreditation in the 1930s. Mr. Sibley is also known for having chaired, during the early 1960s, the General Assembly Committee on Schools, which was tasked with the difficult assignment of ascertaining public sentiment regarding a federal court order that mandated desegregation of Georgia public schools. The so-called Sibley Commission is credited with laying the foundation for ultimately ending massive resistance to desegregation within the state and helping then-Governor Ernest Vandiver avoid a showdown with the federal government. Mr. Sibley remained an active business and civic leader for many more years and passed away in 1986 at the age of 98. The lecture series in his honor has a history that is as rich and distinguished as his life. It began in 1964 and over the years has attracted such academic luminaries as Charles Allen Wright, John Hart Ely, Grant Gilmore, and Stanley Fish, as well as 4 U.S. Supreme Court justices: Chief Justice Earl Warren, Justice Harry Blackmun, Justice Ruth Bader Ginsburg, and Justice Antonin Scalia. The 2 annual Sibley Lectures are underwritten by the Atlanta-based Loredens Foundation, currently headed by Robert Edge, a senior partner in the Atlanta law firm of Alston & Bird. We are incredibly grateful for the foundation's continued generosity and support, without which this wonderful event would not be possible. It is now my distinct pleasure to introduce to you my colleague, Professor Erica Hashimoto, who will introduce our Sibley lecturer. Professor Hashimoto, one of our best and brightest teachers and scholars, joined the Georgia Law faculty in 2004 and teaches criminal law, evidence sentencing, in addition to creating and overseeing the law school's amazing appellate litigation clinic. Prior to joining the faculty, she spent 4 years as an assistant federal public defender in the Office of the Federal Public Defender in Washington, D.C., and served as a law clerk to the Honorable David S. Tatel of the U.S. Court of Appeals for the District of Columbia Circuit, and the Honorable Paul L. Friedman of the U.S. District Court for the District of Columbia. Professor Hashimoto received her bachelor's degree with honors from Harvard University and her law degree, magna cum laude, from Georgetown University Law Center, where she was a member of the Georgetown Journal of Legal Ethics and was inducted into the Order of the Coif. Professor Erica Hashimoto.
Thank you and welcome. I'm so pleased to be introducing today's Sibley lecturer, Professor Robin West. Professor West is the Frederick Haas Professor of Law and Philosophy at the Georgetown University Law Center. She has been and continues to be a dynamic scholarly voice, pushing boundaries and leading through example. She's had an incredibly distinguished career as a legal academic and has written prolifically in the country's leading law journals. And I must add here that her very first law review article was published in the Georgia Law Review. So kudos to our law review for recognizing her brilliance at the beginning of her career. As I was trying to describe the arc of Professor West's scholarly career, I faced a significant challenge in that she has written so much on so many different topics that it is difficult to characterize her scholarship or to put her in any particular academic box. But I've decided that what really sets her apart is her ability throughout her career and addressing all sorts of topics to challenge foundational assumptions in a way that makes complete and total sense. She started her career as an academic in the mid-'80s, writing about jurisprudence and incorporated a feminist legal theory perspective. She quickly became a leading voice in the effort to rethink old problems from a different perspective and to challenge the underlying assumptions of the traditional way of looking at the problem. To give but one example, in an article titled Jurisprudence and Gender, published in the Chicago Law Review, Professor West took on the jurisprudential definition of a human being, almost universally agreed to be an individual distinct or separate from others. As she pointed out, though, women are not essentially, necessarily, inevitably, invariably, always, and forever separate from other human beings. Indeed, they are quite clearly connected to another being when they are pregnant. Once Professor West says that, the point seems really, really obvious. But recognizing that women are simultaneously beings and connected individuals can have enormous jurisprudential implications. My point here is that it has been at the very foundational level that I think Professor West has challenged the law to move forward. Indeed, in almost every area of writing, she has been ahead of the curve, incorporating law and humanities insights into her scholarship over the past couple of decades, long before law and humanities were even discussed in the same sentence, let alone in conjunction with each other. To put it simply, she has helped to fundamentally change not only the way people think about legal issues, but also the way in which they think about scholarship more generally. And so I am truly honored that we have her here to hear her thoughts on the Civil Rights Act, and particularly in light of the history of the Sibley Lectures. I think she is the perfect speaker for this year, coming up on the anniversary of the Civil Rights Act. Please join me in welcoming Professor West for her talk, Toward a Jurisprudence of the Civil Rights Act.
So thank you so much, Erica and Lonnie and the entire law school for this wonderful honor and invitation. I am delighted to be here with you today. The paper was prompted by the anniversary that you just noted of the Civil Rights Act. We're coming upon the 50th anniversary. So the question that I want to start with is definitional. What is the nature of the rights, jurisprudentially, that the 1964 Civil Rights Act legally prescribes? More generally, what is a civil right? That's the question. Today, lawyers tend to think of civil rights, and particularly those that originated in the 1964 Act, as anti-discrimination rights. Are civil rights on this understanding, or are rights not to be discriminated against by employers and schools, landlords, property vendors, hoteliers, restaurant owners, and providers of public transportation, no less than by states and state actors, on the basis of race, gender, ethnicity, age, sexuality, disability, and so on? Contemporary civil rights scholarship overwhelmingly reflects that same lawyerly conception. Our civil rights are quasi-constitutional rights to be free of discrimination in the private as well as the public world. But this conventional lawyerly understanding, basically that civil rights are anti-discrimination rights, is clearly inadequate, certainly with respect to civil rights generally, but also, and more tellingly, even with respect to the rights created and protected by the 1964 Act itself. So first, on the general point, some of the civil rights that have been sought or held across our history have not been anti-discrimination rights of any sort at all. Labor rights, welfare rights, free speech rights, and the constitutional rights of criminal defendants have all at various times been championed as civil rights, and these rights are neither logically nor jurisprudentially tied to any conception of anti-discrimination. But furthermore, even the civil rights which are defined and then protected against discrimination by the 1964 Civil Rights Act, as well as by various civil rights acts both before and subsequent to it, are not, in circular fashion, simply rights not to be discriminated against on the basis of impermissible characteristics. Rather, the civil rights of which we cannot be discriminatorily deprived, whether originating in the 64 Act or elsewhere, are, after all, rights to something: a right to vote, a right to physical security, a right to enter contracts, to own, buy, or sell property, to legal recourse in the aftermath of a wrong committed against us, to write a will, to be considered for or to hold down a job and to be paid fairly for our labor, to the use of a restaurant or a hotel or a city bus, to a public education, or to marry whom we love. And these are just some of the public goods that have been recognized at various times as civil rights, of which we cannot be deprived by discriminatory action. So even if just that much is right, then the civil right protected by all of our civil rights acts, including the 1964 Act, is considerably more complex jurisprudentially than the conventionally legalistic and formulaic equation of civil rights with anti-discrimination rights suggests. Minimally, the civil right recognized or protected by various civil rights acts is almost invariably a multi-layered right, or a right to a right. Wait a second, there's no clock up there. Okay. It's a right to a right. It is a right to not be discriminatorily deprived of some underlying right. Only the first right in that phrase, a right to a right, is the anti-discrimination right. The second right, though, is the underlying civil right of which we cannot be discriminatorily deprived, and it is both itself complex and highly variable. It might be a common law right, such as a right to enter contracts or sell property, or a statutory right, such as a right to vote, or simply a right to a social or public good, such as employment or educational opportunities, or the protection of a trustworthy police force against private violence. And while we have generated a library of writing and jurisprudence and judicial opinions, all on the nature of the first right in that phrase, the right not to be deprived of various rights on the basis of race, sex, and so forth, we have devoted much less to the second right, the nature of the underlying right of which we cannot be so deprived. So my question, to rephrase it now, is what is the jurisprudential nature of that right? What is a civil right jurisprudentially, both with respect to the rights protected against discrimination by the Civil Rights Act of '64, and more broadly, again and more generally, what is a civil right? Oddly, I believe, in spite of their importance in our contemporary public life, we are woefully short on a jurisprudential understanding of civil rights, both with respect to the Civil Rights Act of '64, whose 50th anniversary comes up next year, and more broadly. Although we've recently seen an explosion of scholarship on the history or the histories of both the civil rights movement of the 50s through the 70s and of the civil rights acts that they produced, there has not been, either during or following our various legislative moments that have ushered in civil rights laws, a body of scholarly work engaged in reflective debate over the jurisprudential nature of the civil right they sought to win and then to protect. We simply do not have a scholarly jurisprudential canon that seeks to encompass not only the nature of the anti-discrimination norm that our various civil rights acts codify, but also the nature of the substantive underlying rights that all those rights against discrimination protect. Legal scholars have, for better or worse, focused on judge-made law, and particularly judge-made constitutional law, when engaged in the work of discerning the overarching principles of rights-based jurisprudence, and nowhere is that more clear than in the areas of law and life that are touched by the Civil Rights Acts. I will return to that problem below. Here, I just want to note that for whatever reason, our scholarship on civil rights has shortchanged the complexities of both the Civil Rights Acts and of the civil rights movements and their product, civil rights, broadly construed. We have focused our jurisprudential scholarship almost entirely on the rights to non-discrimination that those acts created. We've neglected the need to understand the nature of the underlying rights of access to social goods, systems of law and institutions, contractual freedoms and powers, property ownership, education, employment opportunities, public accommodation, family life, and so on, that those non-discrimination rights are designed to protect. This is a neglect that matters for at least two reasons, beyond the obvious problem that the neglect itself fosters confusion. There are two distinct worries. First, the lack of a jurisprudence of the Civil Rights Act that would center the underlying civil rights and not just the anti-discrimination norm likely reflects as well as contributes to a lack of appreciation of civil society and of the law that facilitates it, that civil rights historically and today both depend upon and produce. But second, the lack of jurisprudential study of the underlying civil rights protected by the Civil Rights Acts throughout our history has quite possibly skewed and I think truncated our inherited civil rights traditions as well as possibilities for their creative regeneration. Civil rights, as well as the civic and participatory life they facilitate, can be threatened not only by discriminatory private practices of the sort prohibited by the Civil Rights Acts, but by much else as well. Our natural rights to participate in family life can be threatened not only by discriminatory state marriage law that grants rights to form families or marriages to some but not others, but also by private or intimate violence within those marriages that goes unaddressed by states, by a punitive criminal justice system that over-incarcerates marriageable men for trivial or victimless offenses, and by a lack of community support for caregiving obligations. Our civil rights to a healthy and physically secure life can be threatened not only by sexually discriminatory medical treatment or racially discriminatory policing and profiling, but also by a lack of affordable health care, a lack of trustworthy police protection against private or neighborhood violence, and an unhealthy and polluted planet. Rights to decent employment opportunities can be denied as not only by intentional discrimination or neutral rules with discriminatory impacts, but also by a lack of skills and skills training, jobs outsourcing, plant relocations, capital strikes, and high unemployment. Our rights to education are frustrated by a lack of preschool readiness and lack of community support for parents of newborns, infants, and toddlers, as much as by racially discriminatory admissions or school districting policies. So the scholarly focus of the last 50 years on the nature of discrimination and its unlawfulness, rather than on the full array of obstacles that stand as barriers to the enjoyment of civil rights, without insisting on the point that discrimination is but one such obstacle among others, has shrunk our understanding and appreciation of our own civil rights tradition as well as its regenerative potential. So I want to begin that conversation. First, I want to introduce or reintroduce, and then I'll endorse the definition of civil rights put forward by Thomas Paine over 200 years ago, well before the idea of non-discrimination had taken hold, in his famous and indeed iconic pamphlet, The Rights of Man. I will ultimately argue that civil rights are rights to be free of unjust impediments, such as, per the '64 Act, public or private discriminatory practices to the underlying rights we all should enjoy to some set of legally constructed or legally protected social goods or institutions, private property, contractual freedoms and powers, dignified and fairly compensated labor, public accommodations and transportation, high-quality public education, civil marriage, family life, and religious practice, among others, all of which both facilitate participation in civic life and permit us to enjoy our most fundamental human capabilities. Then, secondly, I'll elaborate a bit on this constructed and Painean conception of civil rights by contrasting civil rights understood in that way with what I believe to be an emerging and new paradigm of constitutional rights, which I have called critically elsewhere exit rights. And in the third part, which I might drop depending on time, I want to revisit the Trayvon Martin killing and its aftermath in light of some of the distinctions that I'll draw. So, Tom Paine's conception of civil rights. According to this influential and much quoted definition, it's the first thing that comes up on Wikipedia, provided in Tom Paine's canonical late 18th century essay, The Rights of Man, civil rights are those natural rights that are owed by a government to the people, all of them by virtue of their membership in civil society. Civil rights, Paine held, are a subspecies of natural rights. That claim gets repeated and embraced and indeed insisted upon by proponents of the 1866 Civil Rights Act, 3/4 of a century after Paine wrote. Natural rights, in turn, are rights that we enjoy solely by virtue of our humanity. Their content is derived from our nature, not from any rule of recognition, and we hold them regardless of the accident of the geographic details of our birth. We hold them against our own sovereign, whether or not he recognizes them, and we would hold them likewise against any sovereign. And Paine insisted we all hold them, slaves and American Indians no less than free men. Civil rights are not, however, he went on to say, coterminous with the natural rights which we possess by virtue of our humanity for two reasons. They're a subset with two characteristics differentiating them from that larger class of natural rights of which they partake. First distinction, civil rights, unlike other natural rights, are rights that attach by virtue of one's membership in society rather than solely by virtue of one's humanity. But second, although civil rights originate as natural rights, Paine explained, unlike some of those natural rights, such as rights to the mind and conscience or rights to behavior that doesn't harm others, civil rights are those rights that we cannot perfect standing alone, so to speak, outside civil society and law. We need for the enforcement of civil rights the affirmative assistance of positive law. So defined, civil rights included, Paine argued, quintessentially those rights that pertain to the protection of the physical security of the individual. The security of and protection of the physical body are examples, then, for Paine, of foundational rights that are only imperfectly at best enforceable through self-help. So we trade in our natural rights to self-protection and security, so to speak, for the civil right of the protection of our physical security by the state. So, how does Paine's account of civil rights, again penned long before the Civil Rights Acts of either of the 2 centuries following, before the idea of anti-discrimination as an actionable wrong had gained traction, how does Paine's account of civil rights as natural rights that appertain to man and right of his being a member of society, that's a quote, but to which his individual power is not in all cases competent, that's a quote, how does it stand up as an account of civil rights, both those passed into law 50 years ago and in various statutory provisions both before and since? Better, I think, than our current lawyerly equation of civil rights with anti-discrimination rights. At least echoes of Paine's definition can be heard not only in the Civil Rights Act of '64, but in virtually all of the civil rights acts and movements of both the 19th and 20th centuries. So, really quickly, according to the framers and advocates of the seminal Civil Rights Act of 1866, civil rights include rights to enter and enforce contracts, to buy, hold, rent, and sell property, to sue, to be parties, to give evidence in judicial proceedings, and to enjoy the protection of the state and its laws pertaining to the security of persons and property. All of that fits readily Paine's description of civil rights as that subset of natural rights that should attach by virtue of membership in society and that require legal definition and institutions to perfect. These civil rights, as they were then called, clearly require positive law for their perfection. The power to make and enforce contracts requires contract law. Enforcement of property obviously requires property law. Rights to sue and give evidence requires the law of procedure. Rights pertaining to the security of persons and property requires the criminal law, and so forth. The Civil Rights Act of 1871, one of the enforcement acts passed in the wake of the Reconstruction Amendments, popularly known as the Ku Klux Klan Act, explicitly added personal security from various private conspiracies to commit, among other wrongs, violence against freed slaves, to the list of civil rights to be enforced by the federal government rather than state militias. Here, too, the extension fits Paine's understanding. The natural right to be protected against private violence had been granted by some by virtue of the criminal laws prohibiting it and their enforcement by state authorities, but that protection had not been extended to the protection of the freed slaves against private conspiracies contemplating violence, such as lynchings, against them. Thus, the need for the Ku Klux Klan Act. For the authors of the constitutionally doomed Civil Rights Act of 1875, of course, civil rights also included the right to use public accommodations, such as hotels and restaurants, employ public transportation, enjoy and participate in public amusements, such as theaters. Here as well, these rights to participate sociably in these public spaces of civil society, which attach by virtue of membership in that society, require law for their creation and enjoyment, and the Act of 1875 created a non-discrimination right to enjoy those participatory rights. This act as well then fits Paine's definition. So in the 20th century, the phrase takes on new meanings, but nevertheless holds close to the jurisprudential core of Paine's definition. Thus, as told in Professor Galliba's groundbreaking scholarship from 10 years ago, the idea of civil rights in the post-Lochner era included foundationally labor rights, including not only rights to be free of peonage and involuntary servitude derived directly from the 13th Amendment, but also eventually the right to join a union and the right to strike, as well as rights to minimum wage and safe working conditions. Participation in the labor economy as a free and equal citizen, she shows, was viewed as key to a shared civic life, according to the New Deal-inspired Justice Department-housed lawyers of the 1940s Civil Rights Section, who were responsible for giving content and meaning to the civil rights they were charged to enforce in the 1940s. In Paine's language, these labor rights, then, are natural rights that attach by virtue of our humanity, and civil rights that attach by virtue of our membership in society. So in a now much-studied history during the middle and second half of the 20th century, the content of civil rights shifts away from labor rights per se to rights of minorities to enjoy employment and educational opportunities free of discrimination. And it was during this time that the lawyerly identification of civil rights with anti-discrimination rights takes hold, at least according to historians of the era. Here as well, though, the underlying civil rights to employment, to education opportunities, are fairly described as natural rights owed to individuals by virtue of membership in civil society, which cannot be enforced by individuals standing alone. In the last few decades, by dint of at least occasional, if not common usage, the phrase civil rights is sometimes understood as including various statutorily or constitutionally created rights that facilitate family life, such as the right to marry without regard to sexual orientation, the right to family or medical leave from work necessitated by the birth of a child or the illness of a family member, and a right to be free of intimate violence as protected by the Violence Against Women Act, also understood as including rights derived from various sources to a high quality as well as integrated public education, as imperfectly echoed in statutes such as No Child Left Behind and IDEA, as well as the right to health care, the existence of which is strongly implied by the Affordable Care Act. Here, too, in all of these cases, the underlying natural rights to family, parentage, marriage, safe intimacy, quality education, and access to health care are owed to all of us by virtue of societal membership. And here as well, they are rights that cannot be enforced by any individual without the aid of considerable positive law. So they all look like Painean-styled civil rights. So all of these early, mid, and late 20th and early 21st century civil rights laws, or in some cases still unfinished civil rights campaigns, protect civil rights that loosely fit Paine's definition. Most, although not all, protect those civil rights against some form of race, sex, disability, age, or sexuality discrimination. What they all do, though, is protect civil rights against some sort of unjust social ill, either discrimination or poverty or joblessness or lack of insurance or private violence or unequal allocations of unpaid intimate labor with its consequent disparate impacts in workplaces, that in turn hampers the enjoyment of underlying civil rights. So in all of them, the underlying civil right protected against these pernicious forces is a right to engage or participate in some aspect of civil society: employment, education, marriage, family life, access to health care, physical security, and the mobility that goes with it, contract exchanges, and ownership of property that is in turn facilitated through legal process. And in all of them, again echoing Payne, the underlying right that's being protected, extended, or guaranteed is not simply natural, although it is that, it should attach by virtue of humanity. It's also distinctively civil. It attaches or should attach by virtue of membership in society. So let me extract 4 definitional principles of the jurisprudential nature of a civil right from this application of Payne's definition of civil rights to these examples surveyed above of rights protected by various civil rights acts. So first, a civil right is a natural right, meaning it is a right that attaches by virtue of humanity. In contemporary terms, I think we can restate the point this way, drawing on Amartya Sen and Nussbaum's universalist account of human well-being. Civil rights, like all natural rights, protect or nurture fundamental human capabilities we have by virtue of being human, for long and healthy lives, cultural and intellectual engagement, for play, interacting with the natural environment, and so on, enjoyment of which are the preconditions universally for living a good life. Some of those human capabilities, of course, are nurtured by familial direction during childhood and then furthered and directed by individual effort, requiring nothing more than benign neglect from the state for their flowering. Some of them are also, though, furthered by social institutions and the laws that structure them, and some of them are completely dependent on those social institutions and laws. Thus, our capability for health and longevity is furthered not only by a sensible diet, plenty of exercise growing up in a healthy household, but also by access to health care throughout life. Our capability for mobility and physical freedom is furthered not only by strong limbs developed by natural and healthy maturation, but also by protection against violence and the policing that provides it. Capability for intimacy, not only by the flowering of private lives that seek it and the emotional health that sustains it, but also by the promise of a family life that will be protected by sound policing against external threat and internal abuse. The capacity for sociability, not only by a natural capacity for language, but also by access to legally structured public accommodations and spaces. Our capability for a stimulating mental life in adulthood, not only by being left alone to discover all those Pythagorean theorems all by ourselves, but by a high-quality public education with a sound curriculum and pedagogy and the law that structures it. The civil right in all of these cases is the right to access those institutions and the enjoyment of the laws that structure them, which protect and nurture natural capabilities. The various civil rights acts, in turn, provide that those rights cannot be discriminatorily denied. The same relation holds for newer civil rights. The Affordable Care Act directly protects, through a complex regime of rights and responsibilities, the individual capability to live a healthful life. No Child Left Behind, the Individuals with Disabilities Education Act protect, again through rights, the fundamental capacities we all share for exploring the world and enjoying a lively mental life. The Family and Medical Leave Act encourages capabilities for both work and for family, and state gun safety laws and the Violence Against Women Act aim to do the same for our capabilities for intimacy, mobility, physical security, safe sociability, and freedom from fear. All of these are human capabilities essential to a good life, on Nussbaum and Sen's account, and all of these are protected through the social and civil life that law and society both aim to structure. So our civil rights can be understood as the rights to enjoy the fruits of all of that law, and our civil rights acts, again, as laws that guarantee that they cannot be denied through discrimination. Second principle, civil rights are natural rights that attach not only by virtue of humanity, but also by virtue of membership in society. Briefly, civil rights center our rights to participate in community rather than our rights to be free of it. Anti-discrimination rights are rights of belonging, to borrow from Rebecca Zeitlow's near-biblical usage of that phrase, rights of belonging. The point can, however, I think, be substantially broadened beyond what she intended. First, the underlying civil rights protected against discrimination by the '64 Act, as well as the various civil rights acts that came after it, are also themselves rights of belonging, not just the discrimination rights themselves. They are all rights to belong to or participate in various communities, communities of employers and employees, of landlords and tenants, of buyers and sellers, of students, teachers, and administrators, of neighbors and officials in polling places. The acts protect the civil rights of workers and buyers and sellers and tenants, voters, citizens, students, teachers, producers, and consumers to participate in various communal workplaces, neighborhoods, markets, schools, city halls, courthouses, and voting sites, and to do so through accessing legal forms, rules, and entitlements that structure those locales. They all aim to bring us together contractually, educationally, civilly, and so on. The aim of those laws in toto, then, is a participatory community by virtue of not only the anti-discrimination norm, but also the underlying rights. Civil rights seek to build trust between classes of strangers once indifferent or implacably hostile, and they all do so toward the end of strengthening a community's civic bonds. Other rights won or fought for as civil rights in our history can also be described as rights of belonging in the same way. The civil right to form a labor union and to decent wages for safe labor, for example, were rights of belonging, aiming for a more decent, fair, democratically participatory workplace. Those rights contrasted in ways that parallel the contrast between the constitutional and statutory anti-discrimination norm. But those rights contrasted with the bare and the sterile right to individual liberty presupposed by constitutional rights to contract. Those contract rights at best created free individuals unbound by paternalistic states, empowered, at least in theory, to set terms and conditions of employment by virtue of power of exit. The Family and Medical Leave Act directly aims to strengthen actual communities in the home and in the workplace by pooling the costs of early infant care or the care of sick family members. And the Affordable Care Act likewise strengthens ties of responsibility among those who share risks in insurance pools. Violence Against Women Act aims to protect physical security toward the end of enhancing the protection of women's mobility and safety in the communities of home and civil life. No Child Left Behind, IDEA-style laws aim for stronger communities, both in schools and in neighborhoods that indirectly benefit from this floor of quality they aim to establish, rather than leaving parents and their children to their own individualistically fashioned means, needs, and desires. Some of these laws can be and have been fairly described as anti-discrimination laws, but they obviously cannot be simply described as anti-discrimination laws, and they might not be best described in that way. VAWA, the Violence Against Women Act, most directly targets violence against women, not discrimination against them. IDEA aims to educate, not eradicate invidious distinctions. And FMLA, the Freedom of Family and Medical Leave Act, likewise aims to support parents directly rather than discrimination against women on the job. All of those laws, whether or not they can fairly be described as anti-discrimination norms, aimed quite directly to strengthen civil, communal, or neighborly bonds. Third principle, civil rights distinctively aim to protect those individual fundamental capabilities that are facilitated by law and which, as per Payne, cannot be perfected or enforced by individuals standing alone. The civil right is a positive right of access to the laws, the legal structures, forms, and entitlements that in turn protect or nurture fundamental capabilities that cannot be protected without societal and civil interaction. So, the civil rights acts of both the 19th and 20th centuries empower individuals who would otherwise be barred by dint of private discrimination from various social institutions that depend upon civil society and its law for their very definition. Buying and selling property, contracting for and then occupying hotel rooms, eating in restaurants, working at jobs under the same terms as white co-workers. Likewise, the Affordable Care Act protects the human capabilities of health and longevity through pooling risk, which is facilitated then not by individual effort, but by an intricate and interpersonal jurisprudence, interweaving statute, contract, and property law. Gun safety laws, Violence Against Women Act, protect the individual capabilities of safety, intimacy, and mobility by seeking to limit the isolating fears and inhibitions associated with excessive private violence, and they do so through a set of laws and legal institutions rather than through private arms or exhortations toward individual empowerment. The Family and Medical Leave Act protects individual capabilities for work and family life, not through cheerleading, heroically individualizing parenting, exhorting us all to lean in, but through mandated employer-provided assistance with the cost of childcare. The underlying individual capabilities in all of these cases require legal structures, laws, and social institutions, not unimpeded individual initiative. Without the Affordable Care Act, the ability to live a healthy life is frustrated by poverty that prevents the purchase of insurance. Without FMLA, the ability to care for dependents and remain employed, the ability to participate in both family and work life, is hampered by our inability to share the burden of caring for newborns. Without gun control laws, the ability to move freely through our neighborhoods is hampered by fears for our own physical security. Without education laws, abilities to participate in high culture, as well as in an educated workforce and public sphere, is limited by ignorance and illiteracy. We can't do any of this on our own, in other words, and per Payne, that's where and why civil rights enter the picture. So lastly, civil rights are aspirational rather than positive. They're not a listing of what the state has provided through law, rather they are the rights the state should protect even if it does not. Civil rights to employment, education, safe intimacy, and health are the aspirational rights that we have, even if only imperfectly secured by various statutes. So let me contrast this conception of civil rights, Payne's understanding basically, borrowed and plopped into the 21st century, with the conventional and the truncated understanding of a civil right, that I think wrongly dominates civil rights conversations. First, and as I've stressed, the Paynean conception, unlike the traditional, centers rather than ignores the content of the underlying civil right that's protected by an anti-discrimination norm, rights to contract, employment opportunities, education, and so on. Second, the Paynean conception is aspirational, meaning it's rooted in natural as well as positive law. The civil rights we have are those rights we should have, not just the rights we've already won. Third, and as I want to elaborate in a minute, civil rights, so understood, are neither constitutional rights nor are they quasi-constitutional rights. Their recognition might be necessary to further particular constitutional guarantees, but their meaning and their reach and their jurisprudential implications are not defined or limited by those guarantees of the constitutional texts that provide them. They are determined by our nature, not by our law, constitutional or otherwise. Fourth, civil rights, so understood, are rights to the state support, state law, and state institutions that are necessary for their enjoyment. Under the Paynean view, at least as I've constructed it here, their positivity is a central feature of those rights definitionally, rather than being an awkward and contingent feature that clumsily contrasts with the overwhelming negativity of the constitutional rights with which civil rights are often grouped under the traditional view. Lastly, the barriers to the full development of our capabilities that relate to community participation and that require law for their perfection on Payne's account do not end with discrimination, either public or private. Poverty, poor education, poor health care, and vulnerability to violence are also barriers. So laws that seek to counter those barriers, no less than laws that seek to counter discrimination, are core and not peripheral examples of civil rights acts. Collectively, then, civil rights laws all guarantee rights to which we are entitled by virtue of our membership in society. Some, but not all, do so by providing rights to those rights against private or public discrimination. They all, though, confer rights to participate in civic structures that are products of law: public education, public markets and insurance, secure and safe unarmed communities protected by a trustworthy police force, structured and legally mandated postpartum support in the aftermath of a child's birth. Laws that do so, such as FEMA, VAWA, the Affordable Care Act, Fair Labor Standards Act, NCLB, IDEA, and so on, whether or not they aim at discriminatory public or private conduct, are quintessentially civil rights laws. So next, I'd like to contrast constitutional rights with civil rights. The question then is, are civil rights, both those protected by the Act, the Civil Rights Act, and more generally, best understood as constitutional or quasi-constitutional rights? A number of commentators over the last 10 years, including prominently Bruce Ackerman in his Holmes lectures on the subject, have suggested or argued as much. However, once we include within the scope of civil rights the underlying rights those civil rights acts protect, if that is we include as civil rights rights protected against discrimination rather than just the anti-discrimination right itself, it is clear that civil rights contrast far more than they compare with constitutional rights, and particularly with a set of newly discovered constitutional rights that have been recognized, argued for, or contemplated over the last 20 years or so. Paynean civil rights and constitutional rights, so understood, are not only then not co-constitutive of constitutional law, they are also increasingly on a collision course, and I think it would be wise not to obscure that fact. So let me just draw out the contrast. Civil rights, as I've tried to define them, are rights to be included in a participatory public life. As I suggested earlier, Professor Zeitlo calls the anti-discrimination rights that the Civil Rights Act created rights of belonging. I think that's right, but I would say, I think more inclusively, that the civil rights protected by those anti-discrimination rights are rights to enter. They are rights to enter schoolhouses, workplaces, homes, marriages, neighborhoods, public spaces, hotel restaurants, and so on. Now, contrast those civil rights, the rights to enter, with a group of constitutional rights that cover much of the same lived geography and that have been sought, recognized, or argued for over the last 30 years, which I have elsewhere called rights to exit. The still contested but increasingly recognized constitutional right to homeschool one's children, the constitutional right to die, the right to not buy health insurance, the Second Amendment right to own a gun and use it in self-defense, the ever-embattled constitutional right to procure an abortion, and most recently, the right of religious schools to exemptions from anti-discrimination law for the hiring of their ministerial teachers, and the right of religious and also sometimes non-religious employers to exemptions from the Affordable Care Act, but also from other civil rights acts to protect the sensitivities of conscience. The contrast between the civil right to enter and the constitutional right to exit, I think, can be drawn most sharply, one by one. So, the civil right to public education in contrast to the constitutional right to withdraw one's kids from school and homeschool them, reflects values of shared sacrifice and common purpose, both in the ways in which it is funded and in the content of what is conveyed. The civil right to education is a right to enter a public world of education, while the constitutional right to homeschool is a right to exit just that world. The civil right to unpaid leave during a child's infancy is aimed at permitting a parent to enter a familial and parental relation, as contrasted with the constitutional right to exit such a relation through abortion. The civil right to family and medical leave imposes a responsibility on a community of shareholders, customers, and co-employees for the shared burdens of the costs of the care required to nurture newborns or sick family members, rather than providing an individual right to avoid all of those costs by aborting a fetus. Again, the civil right is a right to enter a world of shared responsibility for parenting, while the constitutional right is a right to exit both the biological relationship with the fetus, but also with other potential caregivers. The civil rights to physical security implied by the Violence Against Women Act and decent gun control laws create a community of trust and shared interest among community members who have laid down their arms and a state's police force, rather than a distrust of either the competency or the desires of the police to provide that protection reflected in the Second Amendment's right to bear arms. The civil right to gun safety, to gun control, is a right to enter that social compact of protection from the state in exchange for forbearance from self-help, while the constitutional right is a right to exit just that social compact. The constitutional right to bear arms, that is. The civil right to health care spreads the burden of sickness and illness over a community through the mechanism of shared risk, as contrasted with the individual's constitutional right to absorb all of that risk through self-insurance, through self-help, or through suicide. The civil right to health care is thus a right to enter a civil world of shared risk, cross-subsidizing insurance, and at the end-of-life communal hospice care, while constitutional rights to die and to refuse insurance are rights to exit just those worlds. And of course, the civil rights to non-discrimination, the rights of belonging, as Zeitler dubs them, protect rights to enter employment and educational institutions, while the freedom of church and the freedom of conscience, now being pressed by scholars and to some extent by courts, protect the rights of churches, the schools and hospitals they sponsor, and at the outside reaches conscience-driven employers to exit those laws through blanket exemptions in the cases of churches themselves and various ministerial and conscience exemptions for the schools and hospitals they sponsor. So in each of those cases, the civil right, unlike the constitutional right, not only envisions a community constituted by the civil right to enter, but rests on an assumption of trust and common purpose between the individual holder of the civil right and his co-citizens. Parents, teachers, neighbors, and taxpayers share the burden of educating children. Employers, co-workers, and customers of an enterprise as partners in the financing and support of new parents. A community of insured individuals and medical professionals share the burdens and risks of sickness of each member of the insurance pool between neighborhoods and police empowered to minimize violence in responsible and humane ways. So in other work, I put forward this claim that these constitutional exit rights represent the first wave of an emerging new paradigm of constitutional individual rights. Unlike earlier First, 14th, and Fourth Amendment rights valorized during the first two-thirds of the last century, this new generation of rights, rights to homeschool, to own and use a gun in self-defense, to procure an abortion, to die, to refuse health insurance, to exempt oneself from anti-discrimination law by referencing one's conscience, all of those are rights that facilitate not just the liberty of individuals within the confines of civic life, but a quite extreme form of exit from civic life and from the community and the state that structure it. They guarantee exit from some aspect of the social contract that defines civil society. The constitutional right to own a gun and to use it in self-defense is a right to not participate in, to exit the traditional liberal social compact by which we disarm, relinquish our right to self-help, in exchange for the sovereign's duty to protect us from private violence. It's a right to exit that part of the social contract constituted by the trade of that right to self-help in exchange for the civil right to be protected from private violence. The constitutional right to die is a right to exit not just life itself and its biological ties, but also the social compact by which that life is protected against self-abnegation. It protects the most isolated, solitary, non-communitarian act an individual can possibly make against the paternalistic interventions of community, family, medicine, or state. The abortion right as well, obviously older but consistent with these newer rights, is a right to exit an unwanted relationship, not only with the fetal life within, but also from the community, the family, the state that seeks to protect it. Both killing oneself and aborting fetal life do, after all, like killing an intruder in justified self-defense, sever those earthly coils. The right to homeschool one's children with no supervision from a school or school board, recognized by some lower courts as well as by school districts in several cash-strapped states, including California, is similarly a right to exit from the civic and shared project of intergenerational public education with its shared liberal norms of tolerance, pluralism, and liberal feminism all. The homeschooling parent seeks to exit the shared communal project of education as well as oftentimes its shared goal of a civic life informed by norms of tolerance, gender and racial equality, and individual but civic autonomy. The right to not buy health insurance, heartily insisted upon by Chief Justice Roberts as well as numerous commentators, is likewise a right to exit, this time from the shared social project of pooling health risks through the mandatory purchase of insurance. All of these newfound rights, the oldest of the group being the abortion right, are echoes of a much older Lochner-era contract right, which within the context of employment conferred an explicit right to exit, at will, the employment relation. So in every one of these cases, the constitutional right found by the Supreme Court, or ardently desired by advocates, is not only not a civil right of belonging, quasi or otherwise, which is how Ackerman characterizes civil rights. All of these civil rights are the antithesis, all of these exit rights are the antithesis of a civil right of belonging. The constitutional right protects an individual's right to exit the very community that the civil right, at least on my conception, protects and nurtures and seeks to promote. Civil rights to enter and constitutional rights to exit are not mutually constitutive, they're on a collision course. So let me draw out one final contrast. Part of what is distinctive about exit rights, rights to homeschool, to kill oneself, to abort a pregnancy, to refuse to buy health insurance, to lethal self-help against violence, and to exemptions from non-discrimination law. And by the way, I am not against all of those rights. But anyway, what's distinctive about those exit rights is their tragic hue. They protect a radical separation of the self from others, or at best, an extreme alienation of the self from the civic national community. The homeschooled child is homeschooled precisely in order to maintain or erect a strict separation from that community. The health insurance holdout wants nothing to do with an obligation to support co-citizens in a mutual web of obligation toward the shared goal of a healthier community. The gun owner risks his own death and that of his loved ones as the price willingly paid for the right of self-defense against hostile outsiders and an ineffectual or worse police force. The free contractor from the Lochner era deals with unhelpful co-contracting employees or employers through the right to exit at will. The suicidal individual and the woman obtaining an abortion are both, of course, dealing in death. In each case, the constitutional exit right separates the individual from some feared part of a biological as well as social community, from a physical relation with a fetus that may threaten a woman's life or well-being, an intruder that endangers a homeowner's life, a public school teacher whose very presence exudes liberal norms of forced ideological inclusion, and most poignantly, of course, the suicidal individual from his own pained body. All of this recalls, if nothing else, classical definitions of tragedy. In the last act of a Shakespearean or a classical tragedy, the characters wind up dead on the stage, with the community or the state from which they came torn asunder. In constitutional tragedies, all those dead individuals, as well as the people who killed them, are shrouded in rights. Civil rights to enter, by contrast, are comic rather than tragic. The last act of a classical or Shakespearean comedy culminates, you may recall, in a community ritual, such as a wedding celebration or the birth of a child, that reaffirms the value of a shared communal life, both for the individuals involved and for the larger society. Our civil rights are comedic in precisely the same way. If Title VII of the Civil Rights Act is working properly, then the last scene of that legal drama is a workplace that's actually integrated, not a society of atomistic individuals who have rights against irrational state classifications. If Title IX is functioning properly, then in the last act, universities and colleges are healthier communities. Women actually play on the sports teams, and African Americans are actually participating in the classrooms. When the Family and Medical Leave Act works properly, actual workers tend to their dependents and their real live families, creating stronger communities in homes and workplaces both. The parent nurtures the newborn child, or the adult child cares for the parent, and both do so without fear of losing their place in a workforce. When civil rights to education are secured, then the classroom is public in all senses of the word, publicly funded, publicly supported, open to all comers, serving the public that funds it. It educates for citizenship and fulfilling lives both. When labor rights are enjoyed, workplaces are healthier, better paid, more participatory. With the civil right to marry secured, the couple weds in a ritual of communal reaffirmation toward the end of a communally recognized shared life. With the civil right to gun safety and gun control, the neighborhood is safe, the individual and the community are supported and healthy. In the last act of these legal comedies, not just individuals, but the communities in which they live are all on stage celebrating the civil rights that unite and support them. So it's important to note, nothing Dionysian and nothing romantic about any of it. These rituals are all made possible by law and by lots of it, not by an inherently sociable nature. All of these rituals, a marriage, the opening of a school, the integration of a workplace, the care of a newborn, the policing of a neighborhood, are not just dependent upon, they are fully constituted by law and by legalism. The workplace, after all, is a product of contract property and labor law. The parent's nurturance of a newborn without fear of losing employment is a product of an act of Congress. A safe neighborhood is the end result of a social compact that exchanges a natural right of self-help with the mutual obligations of a communally funded and manned police force. The healthy individual owes her health to the pooling of risk, itself facilitated by a set of tax and spending acts of Congress. Civil marriage, as commentators on all sides of the debate surrounding its expansion have noted, is a product of law and of legalism and not of faith traditions. There's nothing particularly romantic, in other words, certainly nothing anarchic, about any civil rights. Health care is not something we enjoy by nature's bounty. It's something we enjoy if we've structured our law in a way conducive to pooled risk. Education is not something that Emil will pick up willy-nilly if we just leave him to his own devices. It's a highly structured product of law, bureaucracy, deliberation, compromise, and pedagogy. Safe neighborhoods are not the spontaneous flowering of a natural Homo sapien community in Walden Pond. It's the deliberate outcome of a self-motivated contract through which individuals exchange their own natural rights of self-defense for this web of communal protection. Our own health, not something we enjoy in a state of nature, quite the contrary. Lives in such a state would be nasty and short, even without the brutishness of others. It is something that is produced through effective law, facilitating the production and distribution of medicine and medical care both. An integrated workforce, access to fair labor, not the natural product of a primitive instinct to bargain or unstructured spontaneous contracts without need of public enforcement. Rather, it's the product of legalistic constraints on just those instincts. Civil rights, in other words, speak to our capabilities and our respect for community and our recognition of how law is in service to our communal instincts. They speak to law's virtue and law's necessity, and not to law's mendacity or irrelevance. They are, in short, rights to law, not rights to be free of law. We would not enjoy the goods they promise or the capabilities they protect, health, education, welfare, safe neighborhoods, decent work, family, marriage, and so on, without law's presence. Civil rights do a lot of things, but one very important thing they do is embody our respect for the ways that law constructs, constitutes, and provides architecture for this embattled and bruised commitment to the common good. Do I have 5 more minutes? Okay, so by way of conclusion, that was one possible conclusion, but here's another. By way of conclusion, I want to look again very quickly at the killing of Trayvon Martin, the trial of George Zimmerman for the death, and its aftermath. So the failure to find Zimmerman guilty of second-degree murder may or may not be attributable in part or whole to either intentional or unintentional racism on the part of the jury, the judge, the community, the prosecutors, the expert witnesses, the police force, and the defense team, all those claims we've made. If it was so attributable, then there may well have been a violation of not only the anti-discrimination norm in the abstract, but also of Martin's civil rights, both as I've defined them here and as they're traditionally defined, primarily to security and protection. But whether or not that's the case, I think there is another violation of Martin's civil rights that are revealed by that tragedy, but which is not fundamentally a function of racism, although it is certainly exacerbated by racism. Stand your ground laws, as well as newly broadened self-defense laws that expand the scope of permissible violence and altercations, basically expand the scope of justified lethal force to include scenarios in which a combatant is in fear of his life, regardless of who or what triggered the fight that put him there. You can, that is, stalk someone as long as the stalking is itself legal, pick a fight with him, find yourself losing the fight, consequently fear for your own life, and then fire a gun with the intent and the hope to kill, all in justified self-defense, and that's what Zimmerman did. Martin's mistake was to fight his stalker, and effectively. So Zimmerman's justified lethal violence, because it was lawful self-defense, was not criminal. And that which is not criminal, of course, is legal. So when we expand self-defense law with stand your ground laws and simultaneously protect rights to carry weapons, we have in effect changed the terms of our civil social compact. Some measure of public civic violence is now fully permitted that was fully criminal a very short time ago. When we embrace these broad defenses that shrink the sphere of criminal lethal violence, we not only expand the scope of permissible individual self-help in altercations, we shrink the sphere of the pacific civility that is expected of all of us in public as well as private spaces. If a combatant is permitted to carry a gun, start a fight, and then stand his ground, regardless of what he did to trigger the assault against him, virtually every fistfight, regardless of how it began, becomes potentially a justified homicide. So, the sphere of peaceful coexistence of community is gravely reduced. It seems to me that on Paine's understanding, this entire body of newly made law, with state statutory and U.S. constitutional underpinnings both, far more clearly than the jury verdict acquitting his killer, is a massive violation of Trayvon Martin's civil rights. By virtue of its enactment, Trayvon's civil right to the enjoyment of his physical security and his equally civil right to the state's protection of that physical security, that's what was not protected that night on his walk back from the store to his father's apartment. The core civil right, Paine urged, is the right to the state's protection of one's physical security. That protection to which we have a right is and must be provided by the state. It is the paradigmatic right that we cannot perfect on our own. The authors of the 1870s Ku Klux Klan Act realized this. The authors of the Equal Protection Clause of the 14th Amendment recognized this. The authors of the late 20th century's Violence Against Women Act recognized this. Yet somehow we've lost track of the civil rights underpinning of our right to be protected by the state against private violence. Instead, we've shrunk the scope of the civil right to be protected, and we've constitutionalized various rights to kill each other. So, I'm not urging a massive enlargement of our overly punitive criminal justice system, but it hardly follows from the sad fact that our criminal justice system is so unjust that what we should do is return the streets to the armed. The result of the abandonment of the civil right to protection against violence and the civil duty of the state to provide it, whether through defunding police forces or the expansion of self-defense principles, will continue to be increasing carnage in homes, schools, and on public streets. That carnage, no less than discriminatory law enforcement, is certainly a central civil rights issue of our age. It should not need to rear its head only in the aftermath of spectacularly tragic public killings of innocents. There is now no question but that this breach of our civil rights, the failure of the state to protect all of us against private violence, impacts blacks more than whites, and black youth far more than white youth. It is young black men and boys, more than white men, who are targeted not only by ordinary crime, but also by vigilante neighborhood watch groups staffed by white men carrying guns, and whose death-dealing acts of killing are then tallied as justifiable homicides. The civil right, then, of which young black men are deprived in these circumstances is not only the right to be free of discriminatory policing, discriminatory profiling, discriminatory sentencing policies, it's also the civil right to live out lives without fear of intimate and neighborly, and as it turns out, fully legal violence every time they walk home from their homes to their neighborhood stores. Both they and all the rest of us as well are deprived of that right by virtue of neutral-sounding expansions of self-defense laws, stand-your-ground laws, open carry laws, and constitutionally grounded gun rights, all of which collectively have an horrifically adverse impact on minority communities. But the existence of the civil right these laws offend does not depend on that showing. The thoroughly positive right to a thoroughly positive state-provided protection against thoroughly private violence is maybe the quintessential civil right. It is a right that can only be realized through the enactment of positive law and its fair enforcement. It is the civil right to the protection of the state against the private violence occasioned upon him by George Zimmerman, as accomplished here through the state of Florida's quite intentional shrinkage of its criminal law of homicide, which was denied to Trayvon Martin. A civil right, again, is a civil right to law, in this case to laws criminalizing private violence. That civil right cannot be realized through negative rights to be free of law, but nor can it be realized by rights to be free of state or private discrimination. It cannot even be seen, in fact, as a civil right, so long as we remain besotted by our negative constitutional rights to be free of the state, leavened only by our insistence that the state not irrationally discriminate between us. Neither of these two dominant understanding of rights that circulate in contemporary legal culture, our understanding of our beloved negative constitutional rights that shrink the role of the state in our lives, and our limited understanding of our equally cherished rights to non-discrimination. No matter how seriously we regard all of those rights, they will not help us on this one. All the constitutional rights and all the anti-discrimination rights in the world would not have helped Trayvon Martin against George Zimmerman's fully legal, lethal force. For that, we need to regenerate interest in and commitment to the rights to civil society, including Trayvon's vital civil rights to physical security and mobility, envisioned by early and forgotten architects of our classical civil rights tradition. Thank you.